Welcome to Women Winning Divorce with your host, Heather Quick. Heather brings over 20 years of law experience that advocates and empowers women to achieve happier and healthier lives. Each week, we provide knowledge and guidance on different aspects of family law to help lead women through the difficult and emotional legal challenges that they are facing. Listen in as she discusses issues including divorce, custody, alimony, paternity, narcissism, mediation, and other family law issues to provide insight on the journey of women winning divorce. Welcome to the show. I'm Julie Morgan, and I'm joined by your host, Heather Quick. Heather, I like those flowers you're wearing today. I like that. Looks good.
Why, thank you, Julie. You know, it's spring and summer, so I like to wear some color.
Oh, yes. I like that. You guys should see her, so I'm just telling you, it's awesome. Yeah.
Thank you.
Heather, so last week we talked about what happens, if your divorce goes to trial, right? So today we're going to talk about preparing for trial. As with anything, preparation is key if we want a really good outcome. But how important is it in this context?
It's so very important because you have to be prepared, your attorney needs to be prepared, and there's so much that goes into that if you want, if you're clear on your goals and what outcome you're looking for, preparation is key, and it's going to alleviate some of the stress that you may feel and anxiety, which is normal in, you're about to go to court and trial and all of that. And so that is why preparation is very important and should not be, underestimated or think, oh, we don't need to do that or this. Not true. You do.
So it sounds like, you really need to follow the direction of your attorney, because this is really it's probably not your lane, as a client.
It's not. And if you think it is, you're doing yourself a disservice. And, really, even I will go as far as to say, even if you are an attorney and we have lots of smart, very smart business owners, women, attorneys, doctors, but it is your case. And therefore, your objectivity is skewed, and it's very difficult to, see it through a different lens because it's your case, your life. And so therefore, there needs to be a lot of preparation. And like we discussed last week, it's not like, folks see on TV. And so when you're not familiar, it's so important. What I think is so important, one, of course, everything we need legally and evidence and all that, we're going to talk about that, but that you have an understanding of how it's going to go. Like you understand, hey, what is that layout going to be? Where are we going to be sitting? Who gets to go first? How do things work? Just those logistics in and of itself is so very important. And then knowing, your questions, your evidence, your financial information, you need to know what you're talking about and be prepared and know what questions are going to be coming.
This makes me think of, you said, okay, well, if you are, an attorney, it's probably you understand what's going on, but this is so personal. I wonder if an attorney has tried to cover their own case and how that worked out.
And, sometimes they do. And I don't know, but I know that really when anybody is involved in something as personal as this, your money, your children, things like that, it's very hard to be objective and unemotional. Some people can be, but I think that would all be normal. And even when gearing up for trial, you may have more of an understanding of how things are going to go and you understand the language and procedure. But still, you need to not play the lawyer. You need to be the witness in this case. So that's why that's important, and really working with your attorney, because of course your input's essential to everything. And you need to remain engaged and involved as we prepare for trial and at the trial, of course.
And that's difficult to do when you are the subject. Yeah. So, what sort of witnesses are best?
It really, when we look at the issues, we need to put together a witness list. And as we discussed, that has to happen before trial. We don't surprise people with, we bring in all these witnesses. There is disclosure on who's going to be there and what are they going to testify to, because it has to be relevant to the issue. So let's take just the assets and value. Okay, well, we may need that appraiser as a witness for the value of commercial property or personal property. Now, maybe there's a lot of jewelry. Okay, we have done, we do appraisals of personal property because too often maybe they're not really properly valued. Or guns are really valuable. I don't know really anything about them, but I know they hold their value. Same with certain types of jewelry and things that are that hold their value. So those might be some of the financial experts. Sometimes we do have accountants come in and testify and explain to the court, the value of maybe different assets, like tax implications, so that, those are understood, because very rarely do the husband or wife fully understand, maybe, for example, tax implications, and they're going to be testifying more to their advantage. So you want someone in the courtroom that can, again, provide evidence. I may understand something. I'm not a witness. I'm your attorney. Your attorneys can't testify. So if the court is going to consider something, it has to be brought in through a witness. So that's why there can be multiple witnesses. And that's just the example, like a few who would be present on a financial side. We also have, people who could talk about investments and, what kind of return you're going to get, because the court may presume that gets a little, I'm not trying to get too complicated there, but there's a lot depending on what the issues are and, what outcome we're trying to achieve. That's how we determine what witnesses we may need.
Okay. And you know what? I kind of got a little bit ahead of myself when I asked you about witnesses. That's really not even the first step. The first step is actually what you kind of mentioned in when you were speaking. The first step is to gather all your financial documents. Does it always start with money?
Well, yes, because, and that is a requirement. So when we talk about the rules of procedure, there's a lot of rules on, hey, submission of a financial affidavit. That's in the statute. We don't just make that up for fun and make you do that. And what's called the mandatory disclosure, things you have to disclose. And yes, we rely on the financial affidavit, and so does the court. So it is a roadmap for everything that the two of you own, even if maybe some things are titled, individually or not. And as we've talked in many episodes, there may be more than one, because you come to our office, our first financial affidavit, you may not have as much information about all the finances, or there may be things that you're unaware of. And so through the discovery process, which again does take time, but is important, because we do not want to leave assets out. If you're unaware of them, we need to make sure, we have that complete picture. So then when we prepare the financial affidavit closer to trial, it's going to be as accurate as possible based on what we've learned through discovery.
Okay, so that's why you have more than one. One initially, and then as you move closer to trial, after you've found certain things out, you'll update that one.
Correct.
So it really does all start with money.
Starts and ends with money. And then there's a lot of other stuff in between. But at the end of the day, yes, there are the finances, and it's important.
And what he said, she said, I know that's really not the proper term. He said, she said is not permissible.
Well, yes. I mean, obviously, wife's going to testify, husband's going to testify. And you can say in court, what do you think the value is of something? But sometimes, we really want an expert on that. And what I know we talked about last time, and this is, my point of view, is that if we have no other witnesses to corroborate what you're saying, or disagree with what he's saying, then the court, which is the judge's job to assess credibility and determine what he believes, if there's a conflict in which way he's going to, or she is going to make a decision, then that just sometimes, can be a little risky. Not sometimes, it is risky, because it's not that I doubt your credibility as my client, but you could be nervous. You could get flustered, and you may not, be the best witness throughout on certain things. And so then if there are other people, and sometimes it is friends and family who can testify, like if we're talking about, and that's really going to come more down to the issues of children, or usually, or lifestyle things that you have done. But it may be important. Let's say I'll just use an example. I'll make something up that could easily happen and has. You have your mother testify that, throughout the marriage and even during the divorce, she provides a lot of child care for your children, even when it's supposed to be his time. And so therefore, just establishing with the court, hey, this is what has been going on. And, she can say, hey, when he's working, this is what I do. I pick them up, I transport them and, feed, bathe them or whatever, just because that goes to one of the factors, when we are looking at time sharing regarding the children. So that would be an example of when that would be important to have your parent there who does provide all this child care. So they know they're not just giving opinions. They have been involved. They understand certain things, and they have been with the children and both parents. Sometimes in, substance abuse, they have witnessed things important. So that's why those things are very important to share with your attorney. And then your attorney will, discuss with you, why not we have these particular witnesses.
Okay. And also, just in case one says, "Oh yeah, I'm always with the children," the mother-in-law can say, "That's not true."
Exactly. And yes. And so, although, and hey, your mom is probably going to be biased in your favor, I would hope. But they still are a fact witness, and they can testify. And, we, weave through that to the extent necessary.
And also, gather any evidence. You've mentioned in the past text messages, emails, that sort of thing. Make sure you keep a record of that.
Absolutely. I know I've said this before, and I will say it again. Watch what you say in text, and gather and keep things that you have received from your spouse, anything that you think is relevant. The thing is, I prefer for clients, and I think it's best, bring it all in. I'll let you know, and I'll explain. Our attorneys will explain, we can use this, we can't use this. What does this show? Okay. And that's really the attorney's job. Your job as a client is to even over communicate. Give me all the information, tell me all of these things. We will filter out what is important, necessary, what will be helpful or not. And that is, in my opinion, the best way to do it, rather than you as the client deciding, I'm going to share this, I'm not. Because you may or may not, you may think something that we really is not going to be entered would be, but something else, you might say, oh, that wasn't important. The attorney may find that very important, and we might want to explore that issue, call a witness, things of that nature.
Okay. And then after you've explained to them why this is important, then they'll definitely know for the next time, okay, so should probably share this with my attorney if something comes up.
You would hope so. I again, if as you should, as I've always said, hire an attorney. And if you hire an expert to do your divorce, let them do it. But if you don't give them all the information, then you have handicapped them and you may not get the result that you want based on that. Or, where you show up at trial and then you say things in front of the judge that you've never told your attorney. Not helpful. It's not a good idea. I don't care how bad it is or how bad you think it is. At least we can prepare you um, for that and, discuss how we're going to address it because you're under oath. You have to tell the truth. And if there's anything you don't want in front of the judge, I'm pretty sure your husband probably knows about it and has told his attorney. So therefore, I would say go on the premise that it's going to come out. So tell your attorney first.
You're listening to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. When we return, the conversation continues on preparing for a trial. Stay with us. You're listening to Women Winning Divorce with Heather Quick, owner and attorney for Florida Women's Law Group. Heather, tell me this. What is a pretrial hearing? Explain that to me.
So as the name suggests, meaning before the trial, the judge is going to require the attorneys to be present. Some judges want the parties there as well. And at that time, they are going to really want to know, hey, are we prepared for the trial? There's a lot of requirements by the judge. And every judge differs, but they will have said, have the two attorneys met and reviewed everything? And, are you really done what I've said to do, which is meet, exchange all exhibits, go through and decide essentially what you agree on and what you disagree on. And I know we talked about that previously, that is required by the court. So he's going to look at that. They're going to say, all right, our trial is probably in a week or two at the pretrial. Generally, they set those about 2 weeks ahead, maybe 10 days. And they're going to, at that time, say, hey, have you exchanged all of the discovery, all the financials? And are we extending the date? A lot of times we don't want to receive things up until the day of trial because it leaves you not much time to be prepared. And so, if you're a client, that's not helpful to, at the last minute, provide us with a lot of documents that you think are important. And I understand if you think they're important, but we have obligations under the court and it's just not helpful. And I think it's a natural response because it is the procrastination a little bit, but it is the understanding of the seriousness it's coming up. Oh my goodness, this is in 2 days. But what about this? Oh my gosh, there's this. I had blocked this out. And now you start gathering all these things, sending all these things to your attorney that we may or might not be able to use because, you really didn't appreciate or understand that the judge gives us a date. And so, for anyone listening who has, is going through this, please listen to that as, take it seriously now, look for everything, think of everything, really kind of do a brain dump and write out a list in your mind of everything that could possibly be necessary and then do it, get it to your attorney.
Heather, you speak seriously about so many things, but I feel this is very serious. This is something that the client should pay attention to, close attention.
Yes. And this is, your day in court that is going to end with some decisions and a finality on issues that are so important to you and clearly contested enough between you and your husband that we have to have a judge decide. And as attorneys, our goal is to achieve your outcomes to the best that we can, and to also know that you have had input in this case. And when you wait to the last minute, it puts us in a bind, and that creates, I believe, a belief for a client that, oh, if only this had been allowed in, it would be a different result. And the judge gets to decide, and your husband's attorney will object failure to disclose this earlier. And I mean, that happens really rarely, that it's that going to be that important of a document or something. But if you believe it is and you haven't disclosed it, you just need to understand that it may or may not, and it may have been something, even if we found earlier, whether the court would agree that this could come in, if the other side objected, that's a different story. But if it's because you were late, like that happens. That happens in the courtroom. There are certain rules, and some judges are tougher than others and stricter than others, I will tell you. So some judges will be like, oh, it's okay. You can see this and prepare for it. Others are very, sticklers on the rules, and no, you had an opportunity, you didn't present this earlier, you didn't disclose it, you're not going to be allowed to admit it. So yes, I do, because I know how our clients think, and then they can maybe even attach an importance to some document that maybe doesn't really have that much importance, but now because it didn't get to be used, it just creates a belief that, hey, this could have gone a different way.
So is the pretrial hearing, is that the deadline for submitting evidence?
Most of the time, unless the attorneys agree to extend it. And again, you want to follow the deadlines that we know exist. We might decide, hey, we want to give each other a little more time, but I wouldn't count on that. It depends on the size of the case, the size of the document. What is it? Are we specifically hey, we're due to get documents from a bank this week, that have been delayed. Lots of things and reasons. But, for clients, when your attorneys give you a date, like this is the last day you can give me stuff, I would recommend that you take that very seriously.
And whenever you're presenting a case, does it matter what you present first?
It does, in a way that it needs to make sense. And, what we are doing when we are presenting a case is we want the judge to understand the whole picture. So when I say telling a story, I don't mean something false or anything, but you want it to make sense and flow, because judge is a human being. They're taking notes. It needs to make sense in the order. So we typically do present in an order that we, are going to either address the financials first or the children first. And we want it to flow. So your attorney is going to really determine that. Now, if you filed, which I don't remember if we talked about this last week. I know in the past we've talked about, hey, does it matter if you file first? But if you are the one, if we filed first for divorce, we will present our case first. So that is an advantage, I think. So it will change maybe the way in which we'll present the evidence, because, our case goes first before the husband's.
Okay. No, we did not talk about that at all. That's interesting. Okay. I don't know if you want me to save that for a different time, because I mean, I know we've talked about in the past, okay, other things that affects that. Okay. We didn't talk about that. Mm-mm.
So that will affect what order we go in. And, it's just, you're going to be questioned first in that case. And we're going to really lay it all out. And usually, how we prepare at this office is, we might have 10 pages of questions, and we're going to go through those. And the reason is to establish a cadence, get you familiar, and discuss the things that are going to be at issue. And you want to do that in a way that makes sense, again, with the questions, and then what evidence goes along with the questions. So that, meaning documents, and it's it's a lot of preparation, but then it flows much better once you are there in the courtroom.
What about a deposition? Is that necessary?
Yes, and we typically do depositions before trial. And a lot of times, there will be different experts and other witnesses that will have their depositions taken. And that's very common. And then we will take depositions of the husband or wife. And that way that's the only way, as far as our ability to get information from your husband. We have to go through a deposition. So it can be very effective, and it's good practice, for most clients to have had their deposition taken. And it does give you some insight. I've taken many depositions where husband's very difficult and they don't want to answer a question. They don't want to be, forthright and forthcoming. And that will be apparent later. It gives you some insight, and, they're going to be really argumentative and difficult and rude. I've had that in some cases. And you as the client can determine, hey, are they being really aggressive in the deposition to make you uncomfortable? There's a lot of reasons in psychology why attorneys do what they do, but it does get you used to answering questions under oath and knowing that if you say something different at trial, that will be used against you.
Okay. So, and help me understand this. The deposition comes before mediation. Am I right?
In most cases, it should, um, because typically you take a deposition and you learn a lot of stuff that maybe you didn't know, and which leads you to say, hey, I want these documents. You told me about this. I want to know XYZ. And therefore, you're more prepared before mediation. Again, really, it does depend on the issues and how much is at issue. What are we really fighting about or, disagreeing about? Then the attorney will determine how helpful a deposition will be. But I know very often, if you're like, well, I didn't know this or this, the judge, and let's just say if you were in a hearing and something came out that you were unaware of, the judge is going to look at you. Why didn't you take a deposition? You're completely entitled to take a deposition. And to say you're not taking it to save costs is not a valid reason. And that's where clients, when we're doing this, like, we are doing things to better prepare ourselves and the other side for a resolution. And if we think that's necessary to take a deposition, and often it is, that would be why. It's not a waste of time. Many clients, because they just don't, it's hard to appreciate how helpful that can be to have a deposition.
And before the trial, you practice with the client, right?
We do, depending on how, I think it varies. Some clients, and we've already had a hearing or a deposition, so they've seen more, and that does help. That's also what's very helpful, is because now you have been in hearings, you have seen the judge, so you have at least, who's going to be sitting there presiding over the case. You've been in interactions with the other attorney, so you understand how it's going to go. So yes, by the time it gets to trial, we are able to prepare with the client and go through those scenarios. And typically we know the issues that maybe the other side is going to be more aggressive on, or, how to help the client answer those questions truthfully, but sticking to the question and not elaborating and going on, unless that's a helpful thing to do.
Isn't that difficult, though, to stick to the question? Have you found that clients feel that that's a difficult thing to do?
It depends on their personality. I think, if you are a person who just talks all the time and maybe kind of forgets what you're talking about, and then that's just personality, you might do that. It's also out of nervousness sometimes that you will talk, and so the key is listen to the question. And if you actually can hear yourself talking, that probably means you've been talking too long. So just stop and try to remember what in the world you're talking about, because that's just that. I've said that a million times, but I think that's true. I have found myself, even sometimes when you and I are talking, all of a sudden I ended up and I'm like, where did I go on that thing? I think I went like sideways and kept talking about issues that weren't the first question. So it can happen.
You're listening to Women Winning Divorce with Heather Quick, owner and attorney for Florida Women's Law Group. When we return, we're going to talk about what the client needs to do during trial. Stay with us. You're listening to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. Heather, the day of court. I can get there late, right? You know that's sarcasm.
I know. So, a couple things on the day of court and our trial, and typically it's going to start around 9. The judge has usually some other matters that they always want to get done before we start at 9. Regardless of the time it starts, you want to know where you're going. Again, so helpful if you have had a hearing before, meaning you've actually driven it. You know how long it's going to take. You know where to park, so that you've lessened your nerves, or just take an Uber. Like, do something. If you, particularly if you are nervous and really have more anxiety, then do that. Have a friend bring you, family member. It can be much more calming. They can wait outside even if they're not going to be involved. And any of the external things you can remove is going to be helpful, because the last thing you need is to be speeding, get a ticket, an accident. All very unlikely on the odds, but you don't want that to happen. So yes, arrive early and have thought through who could take you, maybe, or an Uber, anything like that. And we definitely talk to our clients about that, because that's what we want you to do. And you want to make a good impression on the court, which means you are not going to be late and you are going to be dressed professionally.
Okay. And you're just basically trying to make sure there's nothing else weighing on your mind, just kind of clear it all out so you can focus.
Exactly. Yes, this requires your 100% focus.
And I remember you saying the same thing as far as mediation is concerned as well. If you guys want to listen to that show, you can go to our website, womenwinningdivorce.com, to download, subscribe, and listen. But you mentioned the same thing for mediation, and that's just how important this is.
Correct. And I understand that when you're really nervous about something, sometimes your brain, you do stuff that you wouldn't normally do because of the nerves, like go the wrong way and get lost to somewhere how to get. And those things just do happen. That's why, hey, just take that factor out of it and don't drive if you believe that will happen. And most of our clients really do have somebody drive them, and it gives them the support, and that's important as well.
Also, keep your emotions in check. That's important.
It is. And yes, so often there may be testimony and you do get emotional because, one, you're, in front of a judge, and then your husband's there. We're in just a room. That is okay. I'm not asking you to be cold and not be who you are. However, if you are very angry or get way over on the emotionality side and hysterical, that's not going to help anything. And we're going to have to take a break, and you're going to have to calm down, and that's okay if it happens, but certainly not the angry. Like, this is not the time to show it if there are kids involved. But either way, it's like, if there aren't kids involved and you're angry, that's okay. But, this is going to be a business transaction, and we're going to move through it from the court's perspective. But the, extreme emotions, it's not going to help you. It hurts your credibility, and it gets you really worked up. And so therefore you're going to have to then bring yourself down. So that's difficult.
Can you ask the judge, can we have a moment?
Oh, indeed, indeed. But if you happen to have gone off or like show a side of you that is not pretty, um, and everybody knows what I mean by that, the emotional side, the judge may say, no, I want to hear this. Keep on going. It could, but oh, absolutely. And yeah, I mean, I may look at you with my eyes like, but I can't sit there and say, don't talk when I've just asked you a question. I mean, there are certain things that I can do, but if maybe it's on cross exam and they're on a roll and, the court may say, no, no, we can finish here. So it, there may be times, yes. So, and then what that means to them is they want to see this side, they want to hear this testimony. Um, and, that's probably not going to fare well.
Mm. Oh boy, there are so many places I want to go with that, but I'm gonna stay on track. Okay, so facial expressions, you can't let those just fly either. Your words or your facial expressions.
That's right. And you just did a good hand and eye roll. That is, you better not do that in the courtroom, and particularly if you're my client, because that is just not going to work. Now, and let me explain to our listeners, everybody listening, we are in this jurisdiction. And so in Duval County in the Fourth Circuit, in St. Johns County, you are in what you would think of a traditional courtroom. But regardless, when you testify, even in other counties in a witness box, you're very close to the judge. But it's when you're on the sidelines. And so if you're in a smaller room and you're rolling your eyes or making gestures, they can see it. And even if you think they're not paying attention, they are. There was this one judge, this is way back in my law school days. And I was doing a judicial internship and we were allowed to go watch other trials. And this one judge would lean back and you would swear he was asleep. And I just am telling you, like, but anything happened, like he was on it. So they're not sleeping. They are very in tune with the small little things, because that's kind of, your body language shows more about what you think and feel sometimes than your words. So it is extremely important. And, for so many reasons, but if you have children, which tends to be when you have more negative emotions, can have negative emotions about your spouse, the court is really going to take that into consideration. And that is something that, we talk about with clients and really try to help them work through. Again, back to the counseling thing, because if you go in there with hate towards them, it could be very damaging to you.
Yeah, that goes back to something we've talked about. And it's as far as the mental health and going to a counselor, you need to work through it, because this is yet another reason that you need to work through it, really.
Exactly.
Alrighty. So we kind of mentioned this a little bit in the last segment. Stick to the facts.
Yes, and answer the question, because if you're not listening and answering the question, and you do that multiple times, you're going to be viewed as evasive and not answering a direct question. And that affects your credibility. Now, I also said, don't volunteer any information. If they ask you a question, answer it. Your attorney's job is to follow up, during after, say you're cross-examined from someone else. You're going to know, and you're going to do great when your attorney's questioning you. That's where it flows, and you're going to give, your answers that you are, prepared to do. It's when you're cross-examined that they are trying to trick you. So you really need to listen and do your best to answer the question without completely avoiding it. And which goes to just tell the truth. Like, you should have already told your attorney The judge is going to hear it. If you are not truthful, that is more harming to you than potentially the actual truth of what you have to testify about.
Oh boy. Okay. So, I mean, it's very clear. You said they do try to trick you, the other attorney. That's what they're doing.
Well, I mean, that's cross-examination, and it's an art, and that if they're good at it, they can. If you're not listening, and paying attention, because they're going to ask you things you don't want to be asked. Now, we try to, as your attorney, we should bring all that out on our side so you can tell the truth, but explain it versus just being, caught off guard on cross-examination. And, part of what goes on in the courtroom during a trial is there's a lot. And I want to, this is a bit about the body language and things like that. Don't talk to your attorney during somebody else's testifying. Because the judge will get on to you, one, and two, your attorney has to listen to the question, the answer, determine if that they need to make an objection, while also thinking about their follow-up question to that particular question that may not happen, for another 30 minutes. So there's a lot that goes on. And, I tell my clients, I've got 3 things going on in my brain at all times. I won't answer you. And the judge will get on to you, but you can write notes and we can take breaks and communicate. But that is part of the procedure and the rules and the decorum. You really need to take it seriously. And, this isn't where you go, well, Judge, I want to tell you something. You better not do that, because they are not going to appreciate that. That is not the way the procedure works. And you don't, yell out something. That's not true, that your husband says, like, don't do that. Again, not TV. You watch a lot of TV, a lot of stuff happens. That is not the way it should happen. Or movies. We all do. We've all seen all those things.
And also, wait a minute. What if something comes up, and I want to direct something to my spouse, my future ex? I shouldn't do that either.
No, you write it down. You should have a pad and a pen and paper and sticky notes for things that are important, and write down, and not write down furiously and like with all this emotion. Again, make notes, keep yourself occupied so that you don't make a fool of yourself.
Heather, I mean, we don't have that much time left, but I know that's difficult. I mean,
It is.
especially if there's so much going on and there's so much, to discuss. That has to be difficult.
It is. And that's why this is a great topic, because all of these rules, anytime you're in front of the court, it's so important. And your attorney, and if they didn't tell you, well, I'm glad you're listening, but most of the time they will tell you all of these things. And it is important. And also, you are not the attorney. You have hired your attorney. Let them go with it. And the more experience you have as an attorney, you can sense when you're winning. And by that, I mean, I can sense that I have said enough, I have asked enough, the judge gets it, and I'm going to annoy the court if I continue down this path. I'm good. We're good. And that is judgment based on experience, intuition, just all of those things. And by the time you get to this trial, you have hired a professional, you've paid them a lot of money. You need to listen and follow them at that point, because a lot happens during a day of trial, and you need to follow their direction so that you just don't, again, make a fool of yourself or let things get carried away, so that you can then let the judge hear what they need to hear and make the decisions that they need to make.
Oh, Heather. I would love to see you in action one day. Tell me. Any parting words?
Well, I mean, this really reiterates what I just said, but let your attorney be your representative. And that's why, which I don't know if we've done a show on it, but we probably will, on how to pick your attorney. But do your due diligence and make sure that your goals are aligned with your attorney, because you want to be in a position of trust and listening to them. I think when clients don't listen, maybe they don't trust them, or they don't really understand of the ramifications, but have them explain it to you. And, if you are, like I said, if you have a trial next week, I'm not going to suggest that you call us and ask us to represent you at that next week, for all the reasons we've talked about in the last episode. But please listen to this. Talk to your attorney about these things and know that it's coming up if you are going through a divorce. Understand these are things. That's why when your attorney sets meetings and things are delivered to you, it's not arbitrary. It's because they want you prepared and they need to be prepared. And if you have any questions about these things, or, embarking on this, as always, give us a call, and, we're here to help you.
Heather, it's always a pleasure.
Thank you, Julie.
Thank you for listening to Women Winning Divorce. We hope you found information to help you navigate your divorce. If you like our show, please take the time to subscribe and provide a 5-star review. If you need more information, please visit our website at womenwinningdivorce.com, where you will find previous episodes and other helpful content. Join us next week as we continue our journey of women winning divorce.
Tobacco-Free Florida knows how hard it is to quit nicotine, which is why we offer different quit options to choose from for free, like 24/7 quit coaches available over the phone and free 2-week starter kits of quit aids. We're even experimenting with 80s pop music.
I'm giving you up, giving you up, giving you up. I'm letting you know. Come back to smoke. I'll never come back. Come back to smoke. I'll never come back. I'm giving you up.
Or maybe we'll just stick to the ways we know work. Visit tobaccofreeflorida.com or call 1-877-YOU-CAN-NOW for free nicotine